Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content several times a week, 3 to 4 times a week on 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so that you can be updated every time we upload new content. Question number 1. Jim watched a liquor store furtively for some time, planning to hold it up. He bought a realistic-looking toy gun for the job. One night, just before the store's closing time, he drove to the store, opened the front door, and entered. He reached into his pocket for the toy gun, but became frightened and began to move back toward the front door. However, the shopkeeper had seen the butt of the gun. Fearing a holdup, the shopkeeper produced a gun from under the counter, pointed it at Jim, and yelled, "Stop." Jim ran to the door, and the toy gun fell from his pocket. The shopkeeper fired. The shot missed Jim, but struck and killed a passerby outside the store. A statute in the jurisdiction defines burglary as breaking and entering any building or structure with the intent to commit a felony or steal therein. On a charge of burglary, Jim's best defense would be that A. The intent required was not present. B. The liquor store was open to the public. C. He had a change of heart and withdrew before committing any crime inside the store. Or D. He was unsuccessful, and so at most could be guilty of attempted burglary. Take 10 seconds and choose your best answer now. I hope you chose option B. The liquor store was open to the public. Remember, burglary is defined in this jurisdiction as breaking and entering any building or structure with the intent to commit a felony or steal therein. Breaking and entering requires overcoming an obstruction to an entrance. In this case, Jim opened the front door of the store before the store was closed. And in fact, the store was open to the general public. This was not breaking because the door was unlocked and the store was still open. As such, Jim's best defense to burglary would be that the liquor store was open to the public. Let's look at the other options. Option A, the intent required was not present. Well, if you analyze the facts, the statute states that the intent is to commit a robbery or a theft, steal an item within. Obviously, he had every intention of committing that portion of the crime. It's option C. He had a change of heart and withdrew before committing any crime inside the store. This would not necessarily negate his culpability or his guilt on a charge if he had changed his mind, simply. Here, the real answer still, amongst the three that we've analyzed, would still be B. The liquor store was open to the public. As a result, he, in fact, could not have been guilty of the initial element of that crime. D. He was unsuccessful, and so at most could be guilty of attempted burglary. If we look at the statute only requires a breaking and entering, and then entering with the intent to commit the crime, not actually, in fact, committing the crime. So D would not be an appropriate result given the circumstances. So we're left with, again, B as our only option. Question number 2. Ames had painted Bell's house under a contract which called for payment of $2,000. Bell, contending in good faith that the porch had not been painted properly, refused to pay anything. On June 15th, Ames mailed a letter to Bell stating, "I am in serious need of money. Please send the $2,000 to me before July 1st. On June 18th, Bell replied, "I will settle for $1,800 provided you agree to repaint the porch." Ames did not reply to this letter. Thereafter, Bell mailed a check for $1,800, marked payment in full on the Ames-Bell painting contract as per letter dated June 18th. Ames received the check on June 30th. Because he was badly in need of money, Ames cashed the check without objection and spent the proceeds, but had refused to repaint the porch. Bell's refusal to pay anything to Ames when he finished painting was A, partial breach of contract only if Ames had properly or substantially painted the porch. B, partial breach of contract whether or not Ames had properly or substantially painted the porch already. C, total breach of contract if Ames had properly or substantially painted the porch. Or D, total breach of contract whether or not Ames had properly or substantially painted the porch. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. Total breach of contract only if Ames had properly or substantially painted the porch. A breach of contract occurs when a party to the contract does not perform after performance becomes due. Therefore, if performance has not come due, there cannot be a breach. Likewise, if the party substantially performs their obligations under the contract, there's no breach. Performance only comes due after the occurrence of all conditions precedent to performance. Only a material breach will excuse performance. In this case, Ames had painted Bell's house under a contract, which called for payment of $2,000. Bell refused to pay anything to Ames after Ames finished painting because Bell contended in good faith that the porch had not been painted properly. Since Bell's only issue with the new paint on the entire house was the porch, it's likely that Ames substantially performed this portion of the contract. When Bell refused to pay Ames anything, Bell was likely in material breach of this contract, assuming, of course, that Ames had properly or substantially painted the porch. Thus, Bell's refusal to pay anything to Ames when he finished painting was a total breach of contract only if Ames had properly or substantially painted the porch. Let's look at the other options here. If we look at option A, partial breach of the contract only if Ames had properly or substantially painted the porch, there's no discussion of divisibility, so as a result, there would be a presumption that the contract is a contract in its whole, given the fact especially that it is a service contract. So the presumption would be that it is for the entirety of the job itself. Option B, partial breach of contract, whether or not Ames had properly or substantially painted the porch. Again, we're stuck with the reality that this is not likely going to be a partial breach situation, given the fact that it's a service contract. And finally, D, we have total breach of contract, whether or not Ames had properly or substantially painted the porch. Well, that would seem to be unfair if he had, in fact, not properly or substantially painted the porch, then perhaps there'd be something up for litigation. But that being said, the proper answer would be C, given these circumstances presented. Question number 3. Jack and Paul planned to hold up a bank. They drove to the bank in Jack's car. Jack entered while Paul remained as lookout in the car. After a few moments, Paul panicked and drove off. Jack looked over the various tellers, approached one, and whispered nervously, "Just hand over the cash. Don't look around. Don't make a false move, or it's your life." The teller looked at the fidgeting Jack, laughed, flipped him a dollar bill, and said, "Go on, beat it." Flustered, Jack grabbed the dollar and left. Soon after leaving the scene, Paul was stopped by the police for speeding. Noting his nervous condition, the police asked Paul if they might search the car. Paul agreed. The search turned up heroin concealed in the lid of the trunk. Paul's best defense to a charge of robbery would be that A. Jack alone entered the bank. B. Paul withdrew before commission of the crime when he fled the scene. C. Paul had no knowledge of what Jack whispered to the teller. Or D. The teller was not placed in fear by Jack. Take 10 seconds and choose the best answer now. I hope you chose option D. The teller was not placed in fear by Jack. Remember, robbery is the wrongful taking and carrying away of another's tangible, personal property without consent and with the intent to permanently deprive through fear or threat of immediate harm. Here, the teller's response to Jack's nervous whisper was not one of fear. The teller looked at the fidgeting Jack, laughed, flipped him a dollar bill, and said, "Go on, beat it." Had this been considered an actual threat of immediate harm, then the teller's response would have been more serious. Without force or a threat of immediate harm, there can be no robbery. Thus, Paul's best defense to a charge of robbery would be that Jack did not place the teller in fear. Now, if we look at the other options, option A, Jack entered the bank alone. This is improper or not in a choice for this immediate fact pattern, because the fact that Paul acted as an accessory could easily cause him to be charged equally as Jack would have been. So A would be eliminated. B, Paul withdrew before commission of the crime when he fled the scene. He had already, in fact, taken specific action towards the commission of the crime. So the question now becomes, can he, in fact, officially withdraw? If the crime is in fact committed, then no, he could not withdraw. He had already led lended aid and assistance towards the commission of the crime. C. Paul had no knowledge of what Jack whispered to the teller. Not certain that it's required that he have specific knowledge of every factor or of every fact, but he still could be arguably charged equally with the crime. That being said, D is the only answer because while B is potentially true that Paul withdrew before the commission of the crime had fled the scene, the reality was that the major issue here is the fact that the victim or the intended victim was in fact not placed in fear, so he would arguably not be able to be charged under this particular type of crime nor this statute. Question number 4. Ames had painted Bell's house under a contract which called for payment of $2,000. Bell, contending in good faith that the porch had not been painted properly, refused to pay anything. On June 15th, Ames mailed a letter to Bell stating, "I am in serious need of money. Please send the $2,000 to me before July 1st. On June 18th, Bell replied, "I will settle for $1,800 provided you agree to repaint the porch." Ames did not reply to this letter. Thereafter, Bell mailed a check for $1,800 marked payment in full on the Ames-Bell painting contract. As per letter dated June 18th, Ames received the check on June 30th. Because he was badly in need of money, Ames cashed the check without objection and spent the proceeds, but has refused to repaint the porch. After cashing the check, Ames sued Bell for $200. Ames probably will A. succeed if he can prove that he had painted the porch according to specifications. B. succeed because he cashed the check under economic duress. C. not succeed because he cashed the check without objection. Or D. not succeed because he's entitled to recover only the reasonable value of his services. Take 10 seconds and choose what you believe to be the best answer now. I hope you chose option C, not succeed, because he cashed the check without objection. Remember that performance can be excused by the occurrence of a number of events such as an accord and satisfaction. An accord is an agreement to accept a different performance in satisfaction of an existing obligation. The accord by itself does not discharge the prior contract. It suspends the right to enforce the original contract until the accord is fully satisfied. If, however, the accord is in fact not satisfied, the non-breaching party may sue either on the original undischarged contract or for a breach of the accord agreement. Satisfaction is the performance of the accord agreement. Satisfaction discharges both the original contract and the accord contract. An accord must be supported by consideration to be valid. If a debt is not yet due or disputed, part payment is new consideration for settlement or release. In this case, Bell sent a letter to Ames offering to settle the good faith dispute regarding the porch for $1,800, provided that Ames would repaint the porch. Bell then mailed Ames a check for $1,800 and had written on the check that it was payment in full for the Ames-Bell painting contract as per the letter dated June 18th. What Bell had done was propose an accord for Ames to repaint the porch and accept the $1,800 instead of the $2,000 per the original contract. Because there was a good faith dispute, this partial payment is new consideration for settlement. Ames accepted the accord by cashing the check without objection. As such, Ames probably will not succeed in his suit for the $200 because he cashed the check without objection. A would not be an appropriate action because, as noted, there is now a genuine dispute as to whether the porch was painted appropriately or not. And as a result, the negotiated price, the $1,800 price, which was in fact accepted, now becomes the new price under the new consideration. So as a result, A would not be an appropriate action response. B, succeed because he cashed the check under economic duress. That would be inappropriate because he did not in fact cash the check and object to the statement on the check. He simply cashed the check and did nothing. Had he objected, perhaps he could have had a position that would stand up in front of a court of law subsequently. But given that he didn't, he does not. And the economic duress is meaningless if it was not noted and wasn't specifically presented. D, not succeed because he's entitled to recover only the reasonable value of his services. That is generally not an appropriate response overall. It's very difficult to evaluate or value his services up to date. He would argue that his value of services are in fact the totality of the amount. And more importantly, given the fact that the contract itself was non-divisible, D would not be an appropriate response. Question number 5. Jack and Paul planned to hold up a bank. They drove to the bank in Jack's car. Jack entered while Paul remained as lookout in the car. After a few moments, Paul panicked and drove off. Jack looked over the various tellers, approached one and whispered nervously, "Just hand over the cash. Don't look around. Don't make a false move, or it's your life." The teller looked at fidgeting Jack, laughed, flipped him a dollar bill, and said, "Go on, beat it." Flustered, Jack grabbed the dollar and left. Soon after leaving the scene, Paul was stopped by the police for speeding. Noting his nervous condition, the police asked Paul if they might search his car. Paul agreed. The search turned up heroin concealed in the lid of the trunk. Prosecution's best argument to sustain the validity of the search of Jack's car would be that A, the search was reasonable under the circumstances, including Paul's nervous condition. B, the search was incident to a valid arrest. C, Paul had, under the circumstances, sufficient standing and authority to consent to the search. Or D, exigent circumstances, including the inherent mobility of a car, justified the search. Take 10 seconds. Choose the best answer now. I hope you chose option C. Paul had, under the circumstances, sufficient standing and authority to consent to the search. Please remember that the police may search without a warrant if the suspect gives voluntary and intelligent consent to the search. The search is valid even if the consenting party did not actually have the authority to consent, as long as the police reasonably believe that the party consenting had the authority to do so. Here, Paul voluntarily and intelligently gave consent for the police to search Jack's car after Paul was pulled over for speeding. The police did not know Paul was driving Jack's car, and under the circumstances, it was reasonable for the police to believe the car was Paul's, and as such, Paul had the authority to consent to the car search. Therefore, the prosecution's best argument to sustain the validity of the search of Jack's car would be that Paul had, under the circumstances, sufficient standing and authority to consent to the search. Let's look at the other options. A, the search was reasonable under the circumstances, including Paul's nervous condition. That being said, the issue here isn't whether the search was reasonable, it was the issue of consent. And given the fact that Paul agreed to the search, the question really becomes, given that it was not his car, does he in fact have the authority or the right to do so? B, the search was incident to a valid arrest. There is literally nothing at this juncture that lets us believe that this individual would be arrested. He's only fidgeting and he's nervous. Only subsequent to the search do they find the contraband in the vehicle. So as a result, that's not a valid or logical turn of events. Usually, if there's another basis for the arrest, or there's an initial basis for an arrest, a valid arrest, and then there's a subsequent search to that, and something is found during that search, then you could argue that that's a valid search incident subject to an arrest. So B would not apply under these circumstances. D, exigent circumstances, including the inherent mobility of a car, justified the search. That's completely inaccurate. The law states exactly the opposite, that the officers do need cause, or at least consent to search a vehicle. As a result, D would not be appropriate, and we are told in the facts that there is consent to search. So obviously the main question that this question is steering us towards is, did Paul in fact have the right to consent to the search, given that it was not his vehicle? And the answer is yes. So as a result, C would be the most correct choice. Question number 6. Congress provides by statute that any state that fails to prohibit automobile speeds of over 55 miles per hour on highways within the state shall be denied all federal highway construction funding. The state of Atlantic, one of the richest and most highway-oriented states in the country, refuses to enact such a statute. Which of the following potential plaintiffs is most likely to be able to obtain a judicial determination of the validity of this federal statute? A taxpayer of the United States in the state of Atlantic who wants his state to get its fair share of federal tax monies for highways and fears that if it does not, his state taxes will be increased to pay for the highway construction of the state of Atlantic that federal funds would have financed. B. Contractors who have been awarded contracts by the state of Atlantic for specific highway construction projects, which contracts are contingent on payment to the state by the federal highway construction funds to which it would otherwise be entitled. C. An automobile owner who lives in the state of Atlantic and regularly uses its highway system. Or D. An organization dedicated to keeping the federal government within the powers granted to it by the Constitution. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. Contractors who have been awarded contracts by the state of Atlantic for specific highway construction projects, which contracts are contingent on payment to the state by the federal highway construction funds to which it would otherwise be entitled. Article 3 of the Constitution grants judicial power to the Supreme Court and such inferior courts that the Congress may establish. The cases and controversies requirement are limits on the federal judicial power. A plaintiff must have appropriate standing to file suit in federal court. Standing generally requires an injury, causation, and redressability. The plaintiff must allege and prove actual or imminent injury that is personally suffered. The Supreme Court has denied standing for general grievances. In this case, the contractors in B have been awarded contracts for specific highway construction projects, contingent on payment to Atlantic of federal highway construction funds. The federal statute at issue denies Atlantic the federal highway construction funds since Atlantic does not want to prohibit speeds of over 55 miles per hour on its highways. The contractors are suffering injury from the federal statute's denial of federal highway construction funding because their contracts are contingent on Atlantic receiving that funding. The other potential plaintiffs in A, C, and D lack the appropriate standing. Thus, the contractors in B are the plaintiffs most likely to be able to obtain a judicial determination of the validity of this federal statute. Question number 7. Maria is the owner and possessor of Goodacre, on which there is a lumber yard. Maria conveyed to Reliable Electric Company the right to construct and use an overhead electric line across Goodacre to serve other properties. The conveyance was in writing, but the writing made no provision concerning the responsibility for repair or maintenance of the line. Reliable installed the poles and erected the electric line in a proper and workmanlike manner. Neither Maria nor Reliable took any steps towards the maintenance or repair of the line after it was built. Neither party complained to the other about any failure to repair. Because of the failure to repair or properly maintain the line, it fell on the ground during a storm. In doing so, it caused a fire in the lumberyard and did considerable damage. Maria sued Reliable Electric Company to recover for damages to the lumberyard. The decision should be for A. Maria, because the owner of an easement has a duty to so maintain the easement as to avoid unreasonable interference with the use of the servient tenement by its lawful possessor. B. Maria, because the owner of an easement is absolutely liable for any damage caused by the servient tenement by the exercise of the easement. C. Reliable Electric Company, because the possessor of the servient tenement has a duty to give the easement holder notice of defective conditions. Or D. Reliable Electric Company, because an easement holder's right to repair is a right for his own benefit and is therefore inconsistent with any duty to repair for the benefit of another. Please take 10 seconds and choose the best answer now. I hope you chose option A, Maria, because the owner of an easement has a duty to so maintain the easement as to avoid unreasonable interference with the use of the servient tenement by its lawful possessor. An easement and a grant of a non-possessory interest in land that entitles a person to use the land possessed by another. The owner of an easement has a duty to maintain the easement from unreasonable interference with the use of the servient land. In this case, Reliable Electric Company had an easement to construct and use an overhead electric line across Goodacre to serve other properties. As owner of the easement, Reliable Electric Company had a duty to maintain the electric line from interfering with Goodacre. The electric line fell across. Reliable Electric Company failed to repair or properly maintain the line, so Reliable Electric Company is liable for the damage caused by fallen electric lines. As such, the decision should be for Maria because the owner of an easement has a duty to so maintain the easement to avoid unreasonable interference with the use of the servient tenement by its lawful possessor. This question is a perfect example of how generally questions are usually answered justiciously. And what I mean by that is that generally the answer is usually a fairly logical response to the situation. Here, if the owner of land grants permission for a utility company to utilize their land to serve other customers, the likelihood is that the law will protect that individual. So right off the bat, for the most part, you can exclude in questions such as these, C and D, where the electrical company would be the winner. So you should generally be left with the two responses where the landowner would be the individual who would prevail given the circumstances, because again, the judge and the court and the law generally tends to favor the side of justiciousness. Question number 8. Owner owns the Acme Hotel when the International Order of Badgers came to town for its convention. Its members rented 400 of the 500 rooms, and the hotel opened its convention facilities to them. Badgers are a rowdy group, and during their convention, they littered both the inside and the outside of the hotel with debris and bottles. The hotel manager knew that objects were being thrown out of the hotel window. At his direction, hotel employees patrolled the hallways, telling the guests to refrain from such conduct. Owner was out of town and was not aware of the problems which were occurring. During the convention, as Smith walked past the Acme Hotel on the sidewalk, he was hit and injured by an ashtray thrown out of a window in the hotel. Smith sued owner for damages for his injuries. Will Smith prevail in his claim against owner? A, yes, because a property owner is strictly liable for acts on his premises if such acts cause harm to persons using the adjacent public sidewalks. B, yes, if the person who threw the ashtray cannot be identified. C, no, because owner had no personal knowledge of the conduct of the hotel guests. Or D, no, if the trier of fact determines that the hotel employees had taken reasonable precautions to prevent such an injury. Take 10 seconds and choose the best answer now. If you chose option D, no, if the trier of fact determines that the hotel employees had taken reasonable precautions to prevent such an injury, you'd be correct. The owner of the possessor of land must conduct activities on their land in a manner that will avoid unreasonable harm to those outside of the property. If an employee commits a tort in the scope of their employment, the employer will be vicariously liable. This is known as the doctrine of respondeat superior. Here, owner will be liable for torts committed by the hotel employees in the scope of their employment. In response to the rowdy Badgers group, hotel employees patrolled the hallways, telling guests to refrain from throwing things out of the hotel windows. This was probably a reasonable response in an attempt to avoid unreasonable harm to those outside of the property. There's no liability if the employees were not negligent. Therefore, Smith will not prevail in this claim against owner if the trier of fact determines that the hotel employees had taken reasonable precautions to prevent such an injury. Question number 9. Leader is a labor leader in Metropolis. 10 years ago, he was divorced. Both he and his first wife have since married other people. Recently, a newspaper in another city, ran a feature article on improper influences it asserted had been used by labor officials to secure favorable rulings from government officials. The story said that in the 1960s, Leader's first wife, with Leader's knowledge and concurrence, gave sexual favors to the mayor of Metropolis and then persuaded him to grant concessions to Leader's union, with which Metropolis has been negotiating a labor contract. The story named Leader and identified his first wife by the former and current surnames. The reporter for News believed the story to be true, since it had been relayed to him by two very reliable sources. Leader's first wife suffered emotional distress and became depressed. If she asserts a claim based on defamation against News, She will A, prevail because the story concerned her personal, private life. B, prevail if the story was false. C, not prevail because news did not print the story with knowledge of its falsity or with reckless disregard for its truth or falsity. Or D, not prevail if news exercised ordinary care in determining if the story was true or false. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. Not prevail if news exercised ordinary care in determining if the story was true or false. An allegation of fact in reference to a plaintiff that harms the reputation of that plaintiff by reflecting negatively on a character trait is a defamatory statement. Constitutional issues with defamation arise when the defamation refers to a public figure or involves a matter of public concern. When dealing with a matter of public concern, the Constitution requires the plaintiff prove two additional elements. The plaintiff must show that 1, the defamation is false, and 2, fault by the defendant. Fault by the defendant is negligence if the defamation relates to a private person, but malice if the defamation relates to a public figure or official. A public figure can be any person pervasively involved in public affairs or those who have thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved. Here, the alleged defamation is in regards to Leader's first wife. The key is to realize that she is not a public official or a public figure. While an argument might be made that she was once a public figure as Leader's wife, that was 10 years ago, and both she and Leader have since remarried. For this question, she is to be considered a private person. As such, fault by news is negligence instead of malice. The reporter for news believed the story to be true, since it had been relayed to him by two very reliable sources. If news exercised ordinary care in determining if the story was true or false, then news was not negligent and Leader's wife will not prevail in a defamation suit against news. Question number 10. On March 1st, Zeller orally agreed to sell his land homestead to buyer for $46,000 to be paid on March 31st. Buyer orally agreed to pay $25,000 of the purchase price to Quincy in satisfaction of a debt which Zeller said he had promised to pay Quincy. On March 10th, buyer dictated the agreement to his secretary but omitted all reference of the payment of the $25,000 to Quincy. In typing the agreement, the secretary mistakenly typed in $45,000 rather than $46,000 as the purchase price. Neither buyer nor Zeller carefully read the writing before signing it on March 15th. Neither noticed the error in price, and neither raised any question concerning omission of the payment to Quincy. In an action by Quincy against buyer for $25,000, which of the following, if proved, would best serve buyer as a defense? A, there was no consideration to support Zeller's antecedent promise to pay Quincy the $25,000. B, on March 5th, before Quincy was aware of the oral agreement between Zeller and buyer, Zeller agreed with buyer not to pay any part of the purchase price to Quincy. C, whatever action Quincy may have had against buyer was barred by the statute of limitations prior to March 1st. Or D, before he instituted his action against buyer, Quincy had not notified either buyer or Zeller that he had accepted the buyer-Zeller arrangement for paying Quincy. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. On March 5th, before Quincy was aware of the oral agreement between Zeller and buyer, Zeller agreed with buyer not to pay any part of the purchase price to Quincy. A third-party beneficiary exists when two parties make a contract with a shared intent to benefit a third party. For a third-party beneficiary to have contract rights, the third-party beneficiary must have known of and relied upon the contract. Contracts cannot be canceled or modified without the consent of the third party if the third party had knowledge and relied upon the contract. In this case, buyer and Zeller had a land sale agreement. As part of this agreement, buyer agreed to pay $25,000 of the purchase price to Quincy in satisfaction of Zeller's debt to Quincy. This demonstrates buyer and Zeller's shared intent to benefit Quincy, which makes Quincy an intended third-party beneficiary. Buyer and seller are free to change their minds regarding payment to Quincy without Quincy's consent, so long as Quincy is unaware of their agreement establishing Quincy as a third-party beneficiary. Thus, buyer's best defense to Quincy's $25,000 claim is that Zeller agreed with buyer not to pay any part of the purchase price to Quincy before Quincy was aware of the oral agreement between Zeller and buyer. I hope you got that one right. Either way, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content 2 to 3 times a week. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content.